Welcome to our third lecture covering Chapter 7 of our textbook. This chapter is entitled Legally Selecting Employees. Let's go to our second slide. We have in the first lecture covered employee selection, and in our second lecture covered discrimination in the selection process. I do want to clarify one point about Lecture 2. And I promised in Lecture 2 that we would talk about sexual harassment. Then I realized that I was getting Chapters 7 and Chapters 8 confused. I apologize for that. Sexual harassment is rarely an issue in the employee selection process. It's usually after the employee is actively working that we see issues about sexual harassment. So we definitely will cover that topic, but we won't cover it in Chapter 7. We will talk about that in Chapter 8, which deals with the employment relationship once it has begun. In this lecture, we'll be covering our last two items, verification of eligibility to work and the employment relationship more generally. So let's fast forward to verification of eligibility to work. We're really looking at two statutes here. The first is IRCA, which is the abbreviation for Immigration Reform and Control Act. More commonly, this is called the I-9 law. You've probably dealt with this in your lives to date. If you haven't dealt with it as an HR professional or a manager, you've dealt with it as an employee, because as you know, when you go to work for a new company, one of the very first things that they will ask from you is the I-9 documentation. So we'll talk a little bit about that process. Then we'll talk a little bit about child labor. It's not unusual in certain portions of the hospitality industry to employ individuals who are under the age of 18. And so we'll talk a little bit about how that works. So let's get started. We're first of all going to talk about IRCA. The first thing to know about IRCA is that you don't want to violate it. It's a very, very bad idea. There are very significant penalties associated with violating this law, and they can run very high very quickly. Now, of course, you as a manager don't want to violate any laws, but the real world is such that there are going to be times. You don't want there to be times like this, of course. You want to avoid them. You want to be very focused on avoiding them. But life is complex, and there are times where something slips through the cracks and you have a technical violation of this regulation or that regulation. And in many cases, it's not a big deal. Not something you want to do on purpose, obviously, but life happens, and sometimes people inadvertently make mistakes. In many areas of law, that's okay. It's not great, but it's okay. It's the human experience. You don't want to allow that with IRCA. The officials who enforce it are not people with a great sense of humor. They're not people who are going to say, oh, but you tried your best. Oh, we'll cut you some slack. There is no slack. There is no slack. They don't care that it's a technical violation. They don't care that you just didn't fill out the paperwork exactly right, even though this person was eligible to work. They are picky, they are detail-oriented, and they will fine you if they find that there are violations. So this is a law that needs to be of great significance to you in terms of complying with it. When you hire a worker and they come to work on that first day, the first thing you want to do, almost before you shake their hands and welcome them, but certainly within the first 30 minutes, is you want to get their I-9 documentation taken care of. If they forgot the documentation, you do want to at that moment say, thanks for coming. When you've got your documentation, come back and chat with us. If we still have an opening, we'll be delighted to discuss whether your employment will continue. You want to do this first. This is the first thing you want to do. You don't want to allow a person to continue if they don't have their I-9 documentation. You want to make sure you communicate that clearly to the employees. Sometimes it'll be as easy as that person running home, getting their driver's license. They might be back in 15 minutes. Awesome, wonderful. But go ahead and require that they do that. You might be tempted in certain occasions to say, well, but I'm sure this person is eligible after all. They don't speak with a foreign accent. They don't have a surname that suggests that their ancestry is from a different country. So surely they're good to go. This is just a formality. Of course, they've got the documentation. Well, no, it doesn't matter. The law doesn't allow you to treat people differently simply because you are making assumptions about whether this person is possibly not eligible to work in our country or not. Another thing to keep in mind is sometimes people who seem like they're completely eligible to work in our country may not be. For example, they may be Canadians. They may not have any accent that seems foreign to you, and yet they may not be eligible to work in the country. So for those two reasons, you have to treat people exactly the same. People who you think possibly maybe not have the documentation, and also those people who you are persuaded very likely do. So keep that in mind going forward. And don't be surprised if when you start a job, if you forget the documentation, that you may get sent home. Don't assume it's because they're singling you out or they've changed their mind about you. But I would encourage you to get that document ASAP, because if you wait even a few hours, you may find when you come back that they don't have that opening anymore for you. Okay, so the next thing to think about is what documents satisfy the requirements of IRCA. And of course, you can refer to the form for that. Most U.S. citizens who are providing their I-9 documentation will provide a driver's license. It doesn't have to be from Texas, but it could be from Texas, certainly. That driver's license obviously contains a picture, so that allows the employer to confirm, hey, the face on that driver's license is the same face that I'm seeing as my new employee. And then the second item would be a Social Security card. And this, obviously the names have to match. And this demonstrates the eligibility to work. There are certain Social Security cards that are restricted that say the person who has this card is not necessarily eligible to work. But when they are unrestricted, when they don't have that language, then that means this person is eligible to work. So those are the two easiest documents for U.S.-born individuals to provide, and that's what you'll see probably for 90% of the people in that category. But there are loads and loads and loads. Have I mentioned there are lots and lots of documents? Because there are lots and lots of documents that a person can provide. And guess what? It is the option of the employee which documents to provide. So they might show up with a baptismal record from a church in the Upper Peninsula of Michigan that you know nothing about and say, okay, this is my proof. Like, what do I do with this? How do I know if it's legit? How do I know if it fits the standard? You have to research it. What you can't say, and you'll want to say this, I completely get that you want to say this, but what you can't say is, don't you have a driver's license and a Social Security card? Because that would be so much easier. I suppose you could say that, but if they say, no, these are the documents I want to provide, then you have to see if they meet the eligibility requirements. And this can take a lot of research. So you can initially research it through the website, but you may well find that you're going to need to reach out to a government official who enforces that to say, hey, this is what I have. Is this okay? A smart approach to consider, and this isn't necessarily one that you'll be initially in a position to do, is whether you want to use the e-verify process. This is something in which the actual federal government will assist you in verifying the employee that they're eligible to work. There are pros and cons to the e-verify system, but it is one that is used by many, many employers. It's a free service to use. If you choose to use it, you have to use it consistently. You can't just say, oh, I'm suspicious of Bob, so I'm going to use it for him, but I'm not going to use it for Mary because I think she probably is eligible to work. You have to be consistent. So that is an option to consider. And again, it's not something that you would choose to use if you're in a part of a larger organization. Requiring a certain type of document is called document discrimination. You can see how it could result in people who are eligible to work not being considered. For example, let's say that I don't have a driver's license. Maybe I'm eligible to work, but I've just recently moved to the United States. And maybe I don't have access to a car, so I haven't gotten a driver's license. So I might be choosing my passport to be my ID. And so that if you were to require that I have these two documents when I don't have one of them, then you're basically excluding me from employment, which is going to mean that U.S. citizens or people born in the United States are more likely to work for your organization. Well, that could be a type of national origin discrimination. So be careful about your document discrimination, or you want to make sure to avoid it and train your HR professionals. If they see something that they can't find on their list, best practice is to say, wait a second, I'm going to have to research this a little bit more. And probably allow, unless it seems to be fake documents, but probably allow them to continue that day, and then hopefully you'll be able to get an answer by the end of that day. There are times where people will present documents that aren't on the list. I've seen this a lot in asylum cases where somebody is from a particular country that has a particular status with our country, where we're allowing these individuals to come in and stay here because of the difficulties in their particular country. Under those circumstances, many times the documentation they have don't fit into the categories of the I-9. And so you'll actually have to research that particular country. Again, calling the appropriate governmental office can really help with that process. If you really aren't sure how something is working, especially when the employee is saying, no, I am eligible to work, I know this is legitimate, you may need to actually hire an attorney to get all the I's dotted and T's crossed. You don't want to make a mistake in this area. One thing that happens fairly commonly with I-9 documentation is that you'll have an employee who is eligible to work, but their eligibility is not unlimited. Maybe they're eligible to work for 6 more months remaining. In those situations, you can't not hire them. You can't say, well, I don't really want to deal with this every 6 months, or I don't want to deal with this again in 6 months, so we're not going to hire you. No, you can't tell somebody who is eligible currently to work that you aren't going to continue their employment because there's going to be some additional paperwork that needs to be completed later on. But you have to set up some type of tickler system so that you'll remember, hey, in 6 months, I need to revisit this issue, and if Bob doesn't provide the required documentation, I have to end their employment at that time. So the way to approach that is to have a tickler file, some system set up so that maybe 2 weeks before that date, you go to Bob and you remind him or her about, hey, we need the documentation. Maybe sit down and go over the list so that Bob knows what he or she needs to provide at that point. On the last day of eligibility, you need to make sure you have those documents. And if Bob doesn't have it, he may well be saying, but I'll be able to get it in just a few days. You can say that's great, but you can't come back to work until you have those documents in your hand. That's important. They shouldn't work even one day when they are not eligible to work. Now, obviously, Bob in that situation isn't going to come to you and tell you about all of this. He's going to hope that you're not paying attention, that you're not calendaring this information. So it does require a fair amount of attention to detail. I will tell you that it's not unusual for Bob not to be to blame for the documentation problem. Oftentimes it's our federal government's fault that they are backlogged, and Bob has submitted all the documents that he needs to get his document renewed, but it's the government who has been a delinquent. I wish I could say that there's a fix, that somehow or another we can cut Bob some slack since he hasn't made any mistakes, but unfortunately not. The date's the date, whether it's Bob's fault or the government's fault or some other entity's fault. You need to follow those dates very closely. Okay, so we've talked about the I-9 statute, IRCA, and now we're going to talk about the FLSA. We'll be talking a lot more about the FLSA in the next broadcast in Chapter 8, but we're going to just touch a little bit on the FLSA right now. The FLSA deals with several different aspects of the employment relationship. One aspect that it deals with is how the federal government regulates child labor. So we're going to talk about the minimum wage aspects in Chapter 8, and we're going to talk about the overtime payment aspects in Chapter 8. That's not really relevant to how we select employees, so these are for another chapter. This is what we're going to talk about today. Okay, so generally speaking, there aren't a lot of federal limitations on what people under the age of 18 can do in an employment. Workers who are 16 and 17 can work an unlimited number of hours. The only thing is they can't work in what are deemed hazardous jobs. For example, they can't operate a paper baler. There's certain jobs in bakeries and in meat packing plants they can't do. They can't operate certain types of elevators that have kind of an industrial setup. They can't climb ladders. And so you need to be careful, and you need to know what the 16 and 17-year-olds can do if you choose to employ them. But you can employ them, and there's not a lot of hurdles with respect to that. Um, there are some possibilities of employing 14 and 15-year-olds, but as you probably know, there's not a lot of 14 and 15-year-olds who work in corporate America. And the reason they don't is because it is highly, highly regulated. There's lots of things they can't do, and they're very, very restricted in the number of hours that they can work. So as a practical matter, you're not going to hire or employ people probably who are under the age of 16. In most states, there's also, in addition to the federal regulations, a fair amount of state law regulation of child labor. Texas's rules about child labor do exist, but they are very similar to the FLSA. So if you're matching the FLSA, you're probably in pretty close compliance with the Texas state law. Of course, you want to review that to make sure that you are in full compliance with the law. You've probably, especially if you lived in a different state when you were a teenager, you probably were aware of the fact that many states require work permits for minors to get from their schools before they can go to work in businesses. So the business, let's say a 16 or 17-year-old applies to work at McDonald's. Well, in many states, before they can start on that first day, they will need a letter from their school saying, confirming their identity, the hours of employment, all that good stuff. And that is required that the employer keep that document. Oftentimes it has to be kept in the facility where that person works. We don't have work permits in Texas. Now, there is something that some employers do still want that, simply so they can be consistent across all their 50 states. And so there is a provision that provides that schools can provide work permits if the employer wants it, but there is no requirement that there be a work permit. Just be aware, though, if you move to a different state, it's very possible that that state will require work permits, and they may also have significantly more restrictions on what 16 and 17-year-olds can do, both in terms of the number of hours that they can work and the tasks that they can perform. This is a little bit like, with child labor, it's a little bit like the IRCA stuff we were talking about before. Even very small violations can result in dramatic fines. I have dealt with the state of Florida pretty extensively in this area, and even when the 16 or 17 just worked 2 or 3 hours after, and they did it because they wanted to do it, just almost no harm that was done to anyone. Employers are still fined in many cases, and the fines can be pretty darn significant. As a result, it's a good idea when you're dealing with 16 and 17-year-olds in states where there are limitations upon the numbers of hours they work, is to intentionally schedule them less than whatever the law says. Let's say the law says they can work 4 hours. It's probably best practice to only schedule them for 3.5 hours. If the person is entitled to a 30-minute time for lunch, you may want to go ahead and give them an hour for lunch, just making sure that you are giving yourself some wiggle room in the event that somebody doesn't completely follow the rules. You've given yourself an ability to monitor the situation. And in those states, you'll want to also go back and check and audit the records. And if you come across an employee who has been working beyond the hours that he or she has, and you want to document that conversation, probably the first time you have the conversation, you want it to be educational. Hey, just to remind you, these are the rules. You can't work beyond this. You are responsible for keeping track of it. The second time, it would need to be disciplinary, and I probably wouldn't allow that person to continue a third time. But you need to end the employment if somebody is going to continue to violate those rules. So it's an important area to be careful about and to monitor on a very regular basis. Okay, so let's go to, that's the conclusion of our discussion of verification of eligibility to work. We've talked about it from the perspective of, is this person eligible to work in the United States at this time? We've also talked about, is this person old enough to work? And now we're going to talk about the last topic, which is the employment relationship. There's two aspects we're going to talk about with respect to the employment relationship. One is the idea of at-will employment, and the second one, and we're just really just going to barely graze the topic of labor unions. So let's talk about at-will employment at first. I said before how the fact that sexual orientation is not a protected category for employment discrimination, that's one of the big surprises that people have in this course. People assume that that is a protected category, just like sex and national origin and religion and race and color and age and disability status, and it's not under federal law or Texas state law. So that's kind of a big surprise. The other big surprise that people have is with at-will employment in many cases. So let's go through what at-will employment is and then talk about how it actually affects both the employee and the employer. So here's the definition from the textbook. At-will employment is an employment relationship where employers have the right to hire any employee whenever they choose and to dismiss, this is the part we really care about, and to dismiss an employee for or without cause. So with or without cause at any time. The employee also has the right to work for the employer or not, or to terminate the relationship at any time. So the employment relationship continues as long as both parties want it to continue. So that's when we say at will, we mean at the will of the employer and at the will of the employee. But it can end in a heartbeat. Imagine that Bob is a cashier at Target. He's had a rough day. He's had just one more customer who was unruly, difficult. Or, well, let's switch up. Let's make Bob a waiter in a restaurant. And he's had yet again another customer that's been just completely unruly. He slams down his menus and he says to the hostess as he runs out, "I quit." Well, guess what? He has the right to quit. He has the right to leave. He doesn't have to give any notice. He can't leave with your stuff, but he can leave even in the middle of the shift at the absolute most inconvenient time for you, leaving you with all kinds of problems to work with. He can quit at any time. And he has to be paid up until that moment that he said those words, "I quit." So he has the right to leave at any time, with or without notice, with or without reason. The employer also has that same right. The employer can fire Bob at any time, with or without notice, with or without cause. Now, the only limitation on the employer is that it can't be for an illegal reason. Let me add this to it. So the employer can't fire Bob because he's a man, or because he's African American, or because he's a whistleblower. But not for an illegal reason. Okay. So you've probably heard, though, that it's a good idea for employees to give 2 weeks notice before they leave. And in fact, as you become a manager, it becomes more common to give even more than 2 weeks notice. A month notice is oftentimes appreciated and to some extent sometimes expected in certain industries. So where does that come from? Well, it's not because it's required by the employee, but it is smart for the employee to do that when it's possible. And the reason for that is that we talked before about the neutral reference policies most employers have. But one question that does get asked by potential employers when they check references is, would you rehire this person? Now, this is a question that has a truthful answer. Even if the answer is no, and that's the truthful answer, it's not an opinion, but it's just true, right? And so you can't find that to be defamation. So if I don't give my 2 weeks notice and therefore I am no for rehire from my past employer, you might think, well, what do I care? I don't want to go back to work for them. I probably don't. But they may truthfully reveal that fact to a future employer, and that future employer, who might have been lovely to work for, now says, we don't want you. And so it's a best practice to go ahead and give the 2 weeks notice, not to burn any bridges, especially in an industry like the hospitality industry, where you'll kind of run into the same people again and again, and so you don't want to have any hard feelings or hurt feelings along the way. So when you can, almost always give at least 2 weeks notice. Give more when you can, and when you can't, try to explain why that's not possible, and try to leave on as good a terms as possible, burning as few bridges as possible. And of course, when you're the manager, you can't control what your employees are going to do, but training them, telling them what your expectations are in that area, and helping them understand why it's advantageous for them to give you 2 weeks notice can increase the odds that they will in fact help you in that area. The textbook talked a little bit about whether states are at-will employment or not. Texas definitely is. In fact, I would say probably Texas is about as at-will employment oriented as any state in the United States. Really, all states in the United States, with the possible kind of sort of exception of Montana, are at-will states. But what that means does vary. There's a kind of a continuum of how at-will-y a particular state is. Texas is very much at the at-will end. It's very difficult, almost impossible, to successfully sue your employer on a discrimination theory when your employment has ended. So that's an overview of at-will employment. That's one thing you'll hear people say, wrongful termination, or that's not fair, or things like that. Lots of things in life aren't fair, as I'm sure you know, and an employer choosing to end your employment relationship oftentimes isn't fair, but that doesn't mean that there's a legal recourse for that. And so that's a source of a fair amount of misunderstanding that I've seen with employees, and that's how it works in Texas and virtually everywhere else. Okay, so let's talk about the second issue. We've talked about at-will employment. Now we're going to talk a little bit about labor unions and collective bargaining. This is one of my very favorite topics to talk about. I literally could talk easily for 20 hours or more than 20 hours on this topic. It is something I took, I guess, 2 courses in law school on. It's a very complex subject. It's a very fascinating subject. But it's also a subject that we, for the most part, don't spend a lot of time worrying about in Texas as managers, because relatively few of our facilities are unionized, and that includes the hospitality industry. You'll occasionally see janitors or housekeepers being unionized, but those are pretty rare. If you happen to end up working in a facility that is partially or fully unionized, then you're going to need to spend, as a manager, you have to spend a lot of time figuring out what that means and what are the requirements. And so other than letting you know now that you need to spend a great deal of time working through that, I don't want to give a lot more information because you won't remember it when you need it. Another time, though, that is important to be aware of how unions work is that occasionally you may be part of a facility that is going through a union campaign. They're not very common in this part of the country for lots of reasons, but if you encounter union activity, you will definitely want to immediately inform your manager, however that chain of command is. And usually somebody from the HR department, if it's a large organization, or the legal department, and if there's no legal department within the organization, very often an outside attorney will be hired to handle that particular matter. Because running a union campaign is a very involved process. There are lots of very, very picky technical rules about how that happens. So you'll want to not try to wing that. You'll want to seek legal guidance to make sure you are in compliance with all the rules with respect to that. When you are dealing with the union, the core document that you're going to be working with as you work with the union is the collective bargaining agreement, which is oftentimes called the CBA. It's that contract that an employer enters into with that group of employees, that unionized group, and it establishes the rights and responsibilities of the employees and the rights and responsibilities of the employer. What needs to happen in the relationship? It's going to establish work duties and vacation days and healthcare options and pay rates, things along those lines. It becomes that whole agreement, and this actually becomes an employment contract between the unionized employees and the organization. The process of getting a collective bargaining agreement is very, very involved. When you have a collective bargaining agreement, you are not employed at will. You're employed under the terms of that agreement. Employment at will occurs when you don't have a written employment contract. In Texas and really in every state in the United States, written employment contracts are very rare. Other countries, that's not necessarily true, but they're almost non-existent in Texas and in most of the country, unless you are in a unionized facility. And then, of course, you have that collective bargaining agreement. Now, the collective bargaining agreement isn't individualized to that particular worker. All the workers in that particular facility are controlled by that same bargaining agreement. It is true that there are some people who do have written employment contracts. The examples that come immediately to mind are senior executives in a large organization. When I worked for JCPenney, I was there for 17 years and I was an employment lawyer there. For most of that time, there was a handful of people, sometimes as few as 2 or 3, who had employment contracts. Then there were other times where there were, gosh, I would say probably 50 to 70 people who had employment contracts. It can vary significantly over time, but keep in mind, JCPenney had 150,000 employees at times and maybe down to 100,000 at other times. But anyway, even when there was the most common period of time or the biggest number of employment contracts, it was a very, very small percentage of the workforce. And that would be the case for the vast, vast majority of corporations. You will sometimes see government employees having written contracts. You especially see that with public school teachers, that they will have an employment contract. It's not something that's really negotiated over. It's really just kind of the same thing that we see with at-will employment, except that it does have a set term. So if I am hired as a teacher, obviously the school district wants me to continue teaching those students until the end of the year. It's obviously awkward and not very efficient to change teachers in the middle of the year unless, of course, there's a good reason for it. And so that's one of the reasons why we actually do see employment contracts in that context. But generally speaking, in Texas and elsewhere, we don't have a written contract, which means that we fall into this at-will employment relationship. Sometimes people confuse at-will employment with right to work. I'm not even going to define right to work, but just know that right to work is a different concept than at-will employment. Texas is both a right-to-work state and an at-will employment state. There are other states in our country, about half, that are not right-to-work state. They're oftentimes called union security states. But even those states are at-will employment states, unless, of course, an employment contract like a collective bargaining agreement applies. So don't worry about right to work. It really has a very different meaning than at-will employment, and it's not something that we'll be covering over the course of this chapter. Well, we're done with the chapter now. We've now covered all 4 of our topics. We've covered how to select your employees, employee selection during our lecture 1. We've covered discrimination and selection process in lecture number 2. And in this lecture, we've covered verification of eligibility to work and the employment relationship. So we're done at this point. And of course, as always, if you have any questions about the material, please don't hesitate to email me or stop by my office hours so we can discuss this in more detail. I thank you for your attention. I hope you have a great day. Bye-bye.